thought it'd be helpful if we started by just making clear we all understand what third-party funding is in practice. I was going to ask Angus to give us a sort of academic textbook definition, if that's okay, and then turn to Susan and Neil as the representatives here from third-party funders to talk about what it actually looks like in practice and what funding options are currently available in the UK market. Angus, over to you. Okay.
Well, broadly speaking, we're talking about a third party is not directly involved in the case, providing funding for it. There are actually different models that we've identified in our research, so there's no such thing as a single third-party funding product. It's a bespoke product tailored to the needs of a case. But the most common model is where a case is brought to a litigation funder, usually with a legal team in place, and the legal team has identified the strategy for the case. What the funder is doing is seeking to cover the likely costs of a case and to, with confidence in the legal team, actually then take it forward. That would be my quick definition.
Excellent, thank you. Susan, I mean, what sort of options are currently out there in the UK market?
Well, I mean, I think one of the things, just to follow on from Angus, that's important to make clear is that funding is not a loan. So when clients take on this funding, that what the funder is doing is taking the financial risk of the case not succeeding. And that's very important from their point of view, that whilst they're going to pay away some of the proceeds of the action, and I think Neil will talk about the sort of levels you'd expect to look at, the critical point is that there's nothing to pay if the case is unsuccessful. The funder is taking the risk on all or any of the costs. Again, unlike some other products, perhaps like after the event insurance, it's typically a bespoke product, so it can cover all or any of the costs, so it's whatever's required to get the case to the end. It can come in at any stage in the litigation, so that's also important to keep in mind. It doesn't have to come in at the beginning. And secondly then, to think about the types of cases it's good for, pretty much wholly at the moment, the market as it exists in the UK is for commercial cases. So typically any commercial dispute where there is a money outcome. I'm not aware of any particular limitations that funders I'm aware of have on the type of commercial claim, but you're unlikely to see many funders providing this support in consumer cases or in defamation. And certainly in our case, only because I don't like them very much, we don't do construction cases, because I did them in practice and I found them quite boring. But if you keep in mind that it's anything with a money outcome and it's not a loan, that's really what the clients need to have in mind as a possibility for paying the costs of running the case.
Neil?
Yes, typically the funder is looking for a multiple of the funding or a percentage of the damages. When what Susan says about the risk is right, that the funder takes all of the risk. The funder only gets a return from the case when it's successful at the end. So the funder's interests are very closely aligned with the claimant, much more so than anybody else involved in the litigation. It's also important to note that in the UK here, typically the funders are not providing any services at all other than the funding. So the law firm still remains involved, the client still remains the client and runs the case and makes the decisions, controls the decision to settle, and the funder simply provides the funding as required.
And what sort of return is a funder typically looking for?
Typically it would be multiple, so it would be probably 2 or 3 times the funding committed, or a percentage of the damages. The percentage varies very widely, depending on the economics of the case. Obviously, for the funder, it's fundamental that both the funder and the client will see a return to make sure that the case remains viable for everybody involved.
Is there currently any limit on the level of return which a funder can take?
No, because there's not that much case law around, but I think we all take a pretty pragmatic view, which is not only none of us want to see what we're doing challenged, but we also want to make sure that the claimant is motivated. So it seems to us that if they're walking away with anything less than 50% of the proceeds, they're less likely to be motivated to want to see the thing through to the end, because keeping in mind they're only going to recover as well if they are successful. Having said that, one of the things that identifies where one is charging a multiple is that it's critical to understand the value of the claim, because if the value of the claim is overstated and the costs overrun, then there's a danger that that happens. But the fixation that most funders have as their number one objective is, can the defendant pay the amount that's claimed from them? So enforceability and value are 2 really big factors when funders are looking at things. I think just another point perhaps that I suspect we'll come on to a little bit later is, and this bespoke nature of things, is the the appetite for risk. I think there is a reputation developing that funders are risk averse. Actually, in our experience, because we're more able to look at things on very much an individual basis, we're able to take different and more interesting risks with the clients, clearly not taking on cases that aren't going to succeed, but perhaps sometimes being a little braver about exploring aspects of the claim and then developing them with them.